Hello, and welcome to another episode of Legally Correct, Legally Raven-haired. This is Devaney, and today we're actually going to read about pleading from the Federal Code of Civil Procedure. So let's get started. So we are going to start by reading Federal Rules of Civil Procedure, Section 3, about commencing an action. So let's get started. Rule 3, commencing an action. A civil action is commenced by filing a complaint in the court. That is what started. This was amended April 30th, 2007, and effective December 1st, 2007. Notice of Advisory Committee, Rules 1937. 1. Rule 5E defines what constitutes filing with the court. The rule governs the commencement of all actions, including those brought by or against the United States or an officer or agency thereof, regardless of whether service is made personally, pursuant to Rule 4D, or otherwise pursuant to Rule 4E. With this rule, compare former Equity Rule 12, issue of subpoena, time for answer, and the following statutes and other similar statutes which provide a similar method for commencing action. USC Title 28, Section 48, former district courts, practice and procedure in certain cases under interstate commerce law. Section 762, C 1402, petition and suit against the United States. Section 766, C 2409, partition suits where United States is tenant in common or joint tenant. The rule provides that the first step in an action is the filing of a complaint. Under Rule 4A, this is to be followed forthwith by issuance of a summons and its delivery to an officer for service. Other rules providing for dismissal for failure to prosecute suggest a method available to attack unreasonable delay in prosecuting an action after it has been commenced. When a federal or state statute of limitations is pleaded as a defense, a question may arise under this rule whether the mere filing of the complaint stops the running of the statute or whether any further step is required, such as service of the summons and complaint or their delivery to the marshal for service. The answer to this question may depend on whether it is competent for the Supreme Court exercising the power to make rules of procedure without affecting substantive rights to vary the operation of statutes of limitations. The requirement of Rule 4A that the clerk shall forthwith issue the summons and deliver it to the marshal for service will reduce the chances of such a question arising. Committee notes on Rules 2007 amendment. The caption for Rule 3 has been amended as part of the general restyling of the civil rules to make them more easily understood and to make style and terminology consistent throughout the rules. These changes are amended to be stylistic only. Great. Now we're going to look at Federal Rules of Civil Procedure, Section 8A and 8D. So let's go here. Rule 8, General Rules for Pleading. A, claim for relief. A pleading that states a claim for relief must contain a short and plain statement on the grounds for the court's jurisdiction unless the court already has jurisdiction and the claim needs no new jurisdictional support. Number 2, a short and plain statement of the claim showing that the pleader is entitled to relief. And number 3, a demand for the relief sought, which may include relief in the alternative or different types of relief. Let's go ahead and just read them all. B, defenses, admissions and denial. In general, in responding to a pleading, a party must A, state in short and plain terms the defenses to each claim asserted against it, and B, admit or deny the allegations asserted against it by an opposing party. Number 2, denials. Responding to the substance. A denial must fairly respond to the substance of the allegation. General and specific denials. A party that intends in good faith to deny all the allegations of a pleading, including the jurisdictional grounds, may do so by general denial. A party that does not intend to deny all the allegations must either specifically deny designated allegations or generally deny all except those specifically admitted. Denying part of an allegation. A party that intends in good faith to deny only part of an allegation must admit the part that is true and deny the rest. Lacking knowledge or information, a party that lacks knowledge or information sufficient to form a belief about the truth of an allegation must so state, and the statement has the effect of a denial. Effect of failing to deny. An allegation other than one relating to the amount of damages is admitted if a responsive pleading is required and the allegation is not denied. If a responsive pleading is not required, an allegation is considered denied or avoided. See affirmative defenses. In general, In responding to a pleading, a party must affirmatively state any avoidance or affirmative defense, including accord and satisfaction, arbitration and award, assumption of risk, contributory negligence, duress, estoppel, failure of consideration, fraud, illegality, injury by fellow servant, laches, license, payment, release, res judica, statute of fraud, statute of limitations, and waiver. Mistaken designation. If a party mistakenly designates a defense as a counterclaim or a counterclaim as a defense, the court must, if justice requires, treat the pleading as though it were correctly designated and may impose terms for doing so. Pleading to be concise and direct, alternative statements, and consistency. In general, each allegation must be simple, concise, and direct. No technical form is required. Alternative statements of claim or defense. A party may set out two or more statements of a claim or defense, alternatively or hypothetically, either in a single court or defense or in separate ones. If a party makes alternative statements, the pleading is sufficient if any one of them is sufficient. Inconsistent claims or defenses. A party may state as many separate claims or defenses as it has, regardless of consistency. Construing pleadings. Pleadings must be construed so as to do justice. So, Section D, pleadings to be concise and direct, alternative statements, and consistency. Let me read it again. In general, each allegation must be simple, concise, and direct. No technical form is required. Alternative statements of claim or defense. A party may set out two or more statements of a claim or defense alternatively or hypothetically, either in a single court or defense or in separate ones. If a party makes alternative statements, the pleading is sufficient if any one of them is sufficient. Inconsistent claims or defenses. A party may state as many separate claims or defenses as it has, regardless of consistency. E. Construing pleadings. Pleading must be construed so as to do justice. Notice of Advisory Committee on Rules 1937. Note to Subdivision A. See former Equity Rules 25, Bill of Complaint Contents, and 30, Answer Contents Counterclaim. Compare to Individual State and Burns 1933, Section 52104 to 1015, to Ohio General Code. See Rule 19C for the requirements of a statement in a claim for relief of the names of person who ought to be parties and the reason for their omission. See Rule 23B for particular requirements as to a complaint and a secondary action to shareholders. Okay, so I don't need to read all this. This is just how it was been amended. All right, so here we go. This is Rule 8, emphasis on Section A and Section D, which we read twice. So Section A, once again, is claim for relief, a pleading that states the claim of relief and what it must contain. And then Section D talks about pleading must be concise, direct, alternative statements, and inconsistency. So you need to be concise and direct, and you cannot be inconsistent. Cannot be inconsistent. Okay, and now let's read Rule 10. Form of pleadings. Caption. Names of parties. Every pleading must have a caption with the court's name, a title, a file, and Rule 7A designation. The title of the complaint must name the parties. The title of other pleadings, after naming the first party on each side, may refer generally to other parties. Paragraph separate statements. A party must state its claim or defenses in numbered paragraphs, each limited as far as practicable with a single set of circumstances. After a later pleading may refer by number to a paragraph in an earlier pleading. In doing so, will promote clarity. Each claim founded on a separate transaction or occurrence, and each defense, other than a denial, must be stated in separate court or defense. Adoption by reference. Exhibits. A statement in a pleading must be adopted by reference elsewhere in the same pleading or in any other pleading or motion. A copy of written instrument that is an exhibit to a pleading is part of a pleading for all purposes. All right. So thank you so much for tuning in. We read Rules of Civil Procedure, Section 3, Section 8 with emphasis on Part A and Part D, and Section 10. So form of pleadings. This is what's telling us what we need caption, names of parties, paragraph separate statements, and then adoption by reference. So any pleading that's adopted by reference, the same pleading, a statement in a pleading may be adapted by reference elsewhere in the same pleading or in any other pleading or motion. So you have to reference anything you put in there. All right. So moving on. Thank you so much for joining.